morning, good day, good afternoon, depending on where you're connecting from in the world. My name is Emily Max. I work as a researcher at the Geneva Academy of International Humanitarian Law and Human Rights, and I will be moderating today's discussion. Before turning to the presentation of our speakers, there are a few points I'd like to mention on housekeeping and general information. So first of all, for those of you who are not yet familiar with the Geneva Academy, we're an academic institution that provides postgraduate education and also conducts research on areas of international law related to armed conflict. As part of a research department, we organize talks such as this one. We call them the IHL Talks series, and they aim at addressing issues of humanitarian law and humanitarian policies that are contemporary. We organize between 6 and 8 per year, and we're always on the hunt for new topics. So if you have any suggestions on topics of people you'd like to hear from, please don't hesitate to reach out. On housekeeping, you will be able to hear and see our speakers today, but your microphones and cameras are disabled. So if you want to interact with our panelists, specifically for the Q&A session at the end, please use the chat feature. I will select questions on a first-come, first-served basis, but if some of them address similar or the same issues, I will group them and address them in clusters. I know that today's topic can be sensitive and also politicized, so I would encourage everybody interacting with our panelists to be respectful and kind. This is also how I will proceed in moderating the discussion. We will first hear from Geneva Academy student of this year who will give a personal insight as to how it's been to experience the situation from abroad. I'll present her in a minute, and then we'll turn to the panel. Each panelist will have about 12 minutes for their presentation, and then we'll turn to a Q&A session. As a short disclaimer, as I've mentioned, I'm a researcher at the Geneva Academy. I also do consultancy work for Human Rights Watch, who is represented here today by Clive. But rest assured that I only have my Geneva Academy hat on today, and I will act as an impartial moderator. And so now, without further ado, I will present our speakers. As I mentioned, we have today a Geneva Academy LLM student. Her name is Tamara Abu Ramadan. She is originally from Gaza, has been in Geneva since September, and has kindly agreed to give a personal, non-legal insight into the situation. Then turning to the panel per se, we have, in no particular order, Clive Baldwin, who is a senior legal advisor with Human Rights Watch. We also have Nouria Oswald, who is the International Legal and Advocacy Director for Al Mizan Center for Human Rights, Palestinian Gaza-based organization on human rights. We have Professor Marco Sassoli, who is a former director of our institution and also a professor of international law at the University of Geneva and a faculty member at the Academy. And last but not least, we have Professor Yael Ronen, who is a research fellow at the Minerva Center for Human Rights of the Hebrew University of Jerusalem, a professor of international law at the Academic Center for Science and Law, Hod Hasharon University, and the academic editor of the Israel Law Review. Warm welcome to all of you, and a huge thanks on behalf of the Geneva Academy for speaking today, also because we're all in different time zones. So now, without further ado, I'll give the floor to Tamara, and then we'll turn to the panel.
Hello, everyone, and thank you, Emily, for the presentation and for organizing this important and timely panel, and also for giving me the opportunity for sharing my personal insight. First, I would like to state that my heart and my mind is with all the Palestinian people in East Jerusalem, Sheikh Jarrah, Silwan, and the occupied West Bank in Gaza, and also in historic Palestine. For the first time in a long time, we're no longer talking about the situation in Gaza in isolation from the situation in other parts of Palestine. And for me, the unification of the Palestinian resilience, in a sense, is by itself a victory. We Gazans have two parallel systems for calculating our ages. So I am 25 years old according to my birth certificate, but I'm also one intifada, 14-year blockade, and 4 Israeli military operations old. The last Israeli bombardment of Gaza started on the 10th of May 2021 and lasted for 11 days. This happened during my LLM studies here while I'm in Geneva. I often think of myself as part of the minority who succeeded to escape the open air prison to pursue education, knowing that 50% of students try to apply for permits from the Israeli authority and usually receive arbitrary rejections. So my family and friends are all there, and I feel, and in the past few weeks, I felt absolutely helpless, knowing that if we may say, the guards of the prison have gone all crazy on the residents of this prison. So, I mean, all armed conflicts are brutal, right? And it would not make sense to make a comparison between the last act of hostilities in Gaza and the ones before. But as an IHL and human rights student, it is not hard to reach the conclusion from the live events that we've all witnessed in the past weeks that on the face of it, multiple violations have been committed. Whole families were killed and wiped out from the civil registry. Whole civilian neighborhoods are not recognizable anymore. And most importantly, 67 children were killed. So those 11 days have been personally and incredibly hard for my family. I feel comfortable to share this in the environment of the academy, but there was this one night where I thought I might lose my father. Unfortunately, there was bombing very close to our house. Israeli warplanes began bombing 2 residential buildings and the surrounding area of 2 parallel roads in the central Gaza City. For about an hour, bombs rained down the area. The homes eventually collapsed on the families there, and the night later became known as the Al Wahda Street Massacre. It's where I live, and it's where 44 Palestinians, including 18 children, were unfortunately killed. So on that night, my father contacted me while I'm here in Geneva, and he told me that he's sitting on the ground in the corridor of our home, and he thinks this is the safest area in our place. He also told me that he was petrified and he thought that he wouldn't make it until the morning. And no one ever knows when you're so far away and your father is telling you these things, and he's there are no shelters and no safe places for civilians. You never know what to say, especially that he was relying on 100% of absolute luck to make it until the end of the night. My father made it, he survived, he's alive. The Israeli army agreed on a ceasefire, and I thought I was relieved. But unfortunately, still, while in Geneva, I still dream of the war, and I wake up in the middle of the night feeling my bed shaking because of what I think of as a nearby bombing. So what I want to say is that after every war, there's this big feeling of frustration because we Gazans know for a fact that this is going to happen again. And this is a fact for us for a very simple reason that until the moment there has not been accountability attained, the crimes are not punished, and when this is not achieved, then possible violations will go uglier and uglier. The lack of accountability dehumanizes us as people, dehumanizes the people that we've lost, and I believe that we are not numbers, we are humans, and I would really like to keep that in mind during this discussion and any discussion regarding the matter. So thank you again for this opportunity and for letting me share this very personal experience. And back to you, Emily. Thank you again.
Thank you, Tamara, for being so honest and also sharing your vulnerability with us today. Hopefully, it will be a reminder that there are human costs to any conflict on both sides or on every side or sides of the belligerents. And it will frame the discussion in a more human way and not just, a legally dry one. So without further ado, I will give the floor to our panelists and we'll start with Clive Baldwin. Clive, you have the floor.
Thank you, Emily, and thank you to you and the Geneva Academy for organizing this very timely event. And I agree completely, it's important to keep the human element whenever we are discussing war crimes, crimes against humanity, accountability, in order to make sure those crimes are identified and don't take place again. I'm going to talk fairly briefly just about two crimes, ones which Human Rights Watch documented recently in a report, those, but which are rarely, if ever, prosecuted, at least in this format. It's the crimes against humanity of apartheid and persecution. We, as other organizations have done, as we have already found, those crimes were being committed against Rohingya in Rakhine State in Myanmar. And then recently we documented that they were being committed against Palestinians with the elements of the crime of apartheid coming together in the occupied territories. But I'm just going to highlight a couple of things, both the background, the key elements that we found after quite a lot of research, and then the key other part is that there have been, well, no prosecutions of the crime of apartheid, and few, if any, of the crime against humanity of persecution in this institutionalized setting, particularly outside actual fighting. And then I'll just finish by some thoughts based on our experience as to why there haven't been prosecutions of these crimes and what that means for future accountability in terms of criminal investigations and prosecutions. So the crimes, and just to be clear, when Human Rights Watch's findings are violations of international law. So we're using the term apartheid not in a political, historical comparison, but just whether it meets the definition of the crime. And the same with the crime against humanity of persecution. And apartheid is a crime against humanity. It was set out in the Apartheid Convention of the 1970s, an international treaty, which, although of course that was written in the 1970s and explicitly states it includes practices in Southern Africa at the time, meaning South Africa, Namibia, Rhodesia as it was. But it was also even then intended to be an international universal crime. And then it was, of course, one of the distinct crimes against humanity included in the Rome Statute of the International Criminal Court drafted after the end of apartheid in South Africa. So intended to be a crime of global international application. And then persecution being, as we know, an older crime dating back at least to Nuremberg in the 1940s, was also included as a crime against humanity, has been prosecuted in the tribunals, particularly in Yugoslavia, and but was kept as a distinct crime from that of apartheid. I mean, maybe arguments of discussion as to whether the two should have been merged, but they are distinct crimes. So when we were setting it out and finding how to apply these crimes. We have the facts. Do we find there's clear evidence of violations? Life is made more difficult there by there not being any prosecutions, court cases, jurisprudence. But there's three, we would say, core elements of both definitions in both treaties. I happen to go into any of the distinctions in the discussion. There are other experts on the panel. But there are distinct inhuman or inhumane acts which are committed. They're committed as part of a system of systematic oppression by one racial group or another, as a second element, and a third element as part of an intent to maintain that system of domination by one group over another. And one, say, element which we took as an interpretation was that intent to maintain, we took as meaning a essentially permanent situation. And is those elements coming together in the occupied territory, although we'd certainly say that intent you could see in applications at all parts within Israel as well as within the occupied territory. But also that what had changed, or clearly, was that there's the intent to maintain is there. There's not a temporary situation. It's not a temporary situation of occupation or that system of domination. It looks very much like a permanent situation. That is one of the core elements that led us to find the crime against humanity of apartheid was being committed. And the other being that the state of Palestine ratified both treaties, the Apartheid Convention and the Rome Statute. And before the beginning of this year, as I'm sure everyone knows, the International Criminal Court found that does mean it has jurisdiction over the war crimes and crimes against humanity in the Rome Statute committed within the territory, within the occupied Palestinian territory, meaning the territory of the state of Palestine as a state party to the ICC. And then there's the crime of persecution in the Rome Statute definition, intentional and severe deprivation of fundamental rights by reason of the identity of the group. There's a more limiting definition in the ICC than many would argue as its definition under customary international law, that it would only be committed in connection with other crimes against humanity under the Rome Statute. Again, we find that is taking place within the occupied Palestinian territory in the evidence we set out. And again, that's, though, clearly is a distinct crime against humanity. It receives much less attention in public discourse, but is one that could be prosecuted separately, should be considered separately, should be considered could be in very different situations from the crime of apartheid. And another key distinction is, although the crime of apartheid is for racial groups, the crime of persecution is under many other groups, including ethnic, political, and others. So those were the legal outline, and we found it does apply that as in Myanmar and now in the occupied territories. But it's then, how does these crimes against humanity become crimes which are prosecuted and lead to convictions? And in some ways, it could find it extraordinary that there have been not only no convictions, no trials, but no prosecutions of apartheid, and few, I think, of persecutions. Maybe others have, maybe people have some cases, but so these situations of institutional discrimination. So some reasons we would think why this has happened. One is that because the word apartheid, as we still see in reaction to the term, is so associated with the situation in South Africa where the term originated of now decades ago. And in many people's eyes, that's what apartheid means, even if you applying it in a legal term. And then, of course, in South Africa, there were no prosecutions. There was a decision not to prosecute anyone for the crime of apartheid or most of the crimes committed under apartheid. And for that is the reason I understand why South Africa itself is still not ratified the Apartheid Convention, although there remains discussions as to whether they will do so. Another term which is used a lot, we didn't use because we didn't find it has a meaning in international law, is that apartheid state. And again, we don't hear it in other crimes. Rarely do you hear people talk about a torture state or even a persecution state. But it may be a deterrent to those considering prosecutions if they think the entire state has to be found essentially to be criminal. It's not the case under the definition. Of course, crime against humanity has to be a state policy or an organizational policy, but it's not one where it requires finding a criminalization of the state. Another reason may be that for apartheid, at least, is the term racial group, and clearly that had different meanings and understandings in the 1970s as it may do today. Again, we found that the evolution and understanding of racial discrimination or racial group, including under the crime of genocide, but also in international law on racial discrimination, particularly the Third Committee and its approach, gives a fairly sort of broad definition, one which is not just based on genetics or color, and could apply in many situations. And that also, of course, would apply to the crime of persecution, which again has a much broader definition. But two other key areas, I think, which are particularly important, is that both crimes require a proof of intent to discriminate. And that's clearly set out in the crime of persecution. And that will be difficult to prove to a criminal level of proof and at the level of crime against humanity. And that is as it should be, but it's that a crime against humanity should be a rare prosecution, it should be difficult, but it should still be possible. And the situations of state institutionalized discrimination will be ones where, if it exists, it's going to be in some ways accepted or shown by state policies, practices, and even statements by leading figures showing their intent to discriminate. So in those situations where the crime against humanity of either persecution or apartheid has taken place, it ought to be possible to find the evidence to show intent. Again, it will be limited to the worst situations, but it should be possible. So the final reason why it may be that so few even attempts to investigate have been done is, I would put forward, is because those who do the international criminal investigations, prosecutions, will rarely have access to the sort of level of knowledge, expertise about discrimination, institutionalized discrimination. That's at that level. It's a different type of expertise. For myself, I come from that background of doing discrimination law in civil claims, even at an institutional state level, but it requires normally a different level of knowledge than those finding evidence of particular crimes like torture, like war crimes and others. So that we may think is key. And that's what we would say for ICC prosecutors and elsewhere, other countries and those taking up universal jurisdiction cases, to consider these crimes, apartheid and persecution more broadly, is to bring in that expertise to consider how to show and understand institutionalized discrimination, how to prove intent. And with that knowledge, first of all, starting the Office of Criminal Investigations, it would finally start to bring that expertise in. And the other area which would help those doing the investigations is development of more soft law and other standards. And a key development this year, separately from criminal law, maybe at the Third Committee, is the interstate case between Palestine and Israel. That's still being considered by the Third Committee, but if and when they make a decision on the merits, which may be this year or next year, I think, they may well rule on what apartheid means under the Third Convention, which it's in there, requiring states to condemn and prevent apartheid, but they've never given a clear definition. So that won't be at the criminal definition, but it may well be a help in saying what apartheid means and how it can be proven. So those are the steps which are needed. Some of them are technical, but some of them may be like political will. And that's why I finally would say what's going to come forward is a key element in the coming years to address these crimes will be the Office of the Prosecutor or the ICC. So before she left, the outgoing prosecutor did open the investigation following the ruling of the chamber this year into war crimes in Palestine. We have said in our report that prosecutors should also now look at the crimes against humanity of apartheid and persecution. And therefore, it will be a critical element that the prosecutor is able to do this, despite some of the resistance of not just non-member states of the ICC, but member states of the ICC to this investigation. But by having both that technical knowledge, reaching out to the experts, but looking at where these crimes take place, and when and if the ICC can make a ruling, it will give everyone the clear guidance to show when these crimes take place and how they should be prosecuted, and by prosecution, prevented in the future. Thank you.
Thank you so much, Clive. I truly believe that HRW's report is a conversation opener as to how to pursue accountability for those crimes, but also how to legally conceptualize them and clarify the elements that still need clarification. And in that spirit, if our panelists want to add or comment on your presentation, they should be welcome to. Professor Sassoli, you have the floor.
Thank you very much. First, a clarification, Emily. Did you say 10 minutes or 20 minutes? My understanding was 10 minutes.
Yes, it was.
Okay, fine. I try to respect that. No, I don't accuse in any way Clive, because you said 20 and he was between 10 and 20. Okay, so first, perhaps a disclaimer, which is always important when you speak about humanitarian law wherever in the world. Armed conflicts are inhumane and occupations are inhumane, and we have to avoid armed conflicts and we have to avoid occupations. Humanitarian law does not condone armed conflicts nor occupations. It simply applies to them, and it allows certain things and it prohibits other things. And I wouldn't even say it allows, it simply does not prohibit certain things. So when I, as a professor or as an expert, or even when I was ICSC delegate, when I went to the Ministry of Defense of a country to discuss, and the enemy of that country bombed the ministry, and I am killed, and I don't like to be killed. Nevertheless, this is not a violation of international humanitarian law. I'm an incidental victim of a lawful attack against the Ministry of Defense. Now, let's speak about our context. And first, let us admit that many, but not all, facts are controversial. Not all, fortunately, because then you can have a legal discussion, because when the facts are controversial, how can you have a legal discussion? And I should clarify that, as you all know, there's no reciprocity in international humanitarian law. Nevertheless, and I think the Academy was right to take it broadly, not just the bombing of Gaza, but the settlement policy, including the specifics of East Jerusalem. And the settlement policy is a clear violation of international humanitarian law, but it cannot justify that Hamas deliberately attacks the civilian population in Israel through indiscriminate attacks, which they themselves say that they are directed against the population, against the Israelis. And even if these are clear violations of humanitarian law, this can obviously not absolve Israel when it uses force to stop those attacks, to respect international humanitarian law, which mainly means only to attack military objectives, to respect the proportionality rule, and to take all feasible precautions. Now, let us speak about, very shortly, about the three aspects. The first one is about the settlement policy. And somehow, the settlement policy is clearly unlawful. and it falsifies the relationship between apartheid and international humanitarian law, because in an occupation, discrimination is logical and inherent in humanitarian law, that the occupying power may not even treat its own citizens in the same way than the protected civilians in the occupied territory. And if the law of occupation was respected and there was no settlement policy, this would somehow not create major discussions, because anyway, there would be only Israeli armed forces. I oversimplify, in the occupied territory, and that Israel doesn't have to treat its own armed forces in the same way than the Palestinian civilian population seems logical to everyone. And I think no one would say, yes, but this is apartheid. While if there was no occupation, a lot of things which are clearly lawful in occupation would indeed constitute apartheid. So through the take-the-land policy, there are plenty of Israeli civilians in the occupied territory. And this brings up this discussion. I would nevertheless say that the law of occupation is the prevailing legal regime in the case of an occupation, and what is lawful under the law of occupation cannot constitute apartheid, because this is a lex specialis for armed conflict and occupation. And so I would say the best defense for Israel against the accusation of apartheid is to stress that this is occupation, but it must then also comply with the law of occupation. And therefore it would be in the interest of Israel to avoid that all this ends up in apartheid, to stress that it is occupation and not to deny that it is occupation, because if it was not occupation, then obviously I would agree that a lot of policies constitute apartheid. Now, the specific case of Jerusalem is even more complicated. Let us assume, because there the facts are controversial, that it is true what the Israelis claim, that these houses in Sheikh Jarrah belonged before 1948 to Jews. And they were expelled in 1948, or they fled in 1948, and then Palestinians started to live there. And now these Jews tried to, or their successors, or the people to whom they sold these houses, tried to get it back. Let's assume that this is correct. What does that mean under the law of occupation? I would say the law for the law of occupation, 1967 is a clear slate. This is the dividing line. So when you are an occupying power, you have to respect the local legislation, which was the Jordanian legislation applicable in East Jerusalem at the time. And at the time, I assume, I didn't make an analysis into it, the lawful owners of the houses were the Palestinians who lived there. Now, obviously, the occupying power does not have to respect all laws. If they are discriminatory, it may, in some cases, disregard them. But Israel cannot claim that this law is discriminatory, because it has itself exactly the same legislation about enemy aliens no longer being owners of the houses. And therefore it cannot say this is discriminatory, because they do it themselves. So therefore I would argue that simply who was the owner in the Middle Ages or in 1948 does not matter if we are in a case of occupation. Just as a subsidiary point, let us, for a moment, don't quote me, forget about occupation. Let us assume that there is no occupation and there is one Jerusalem. Then there is a very serious discrimination, because if you lost as a Jew land in 1948, you can get it back. But if you lost as a Palestinian land in 1948, in one Jerusalem, West Jerusalem, for instance, or in Lod or wherever, you cannot get it back. So you see why, in my view, Israel would have a great interest to insist on occupation, because otherwise this is very serious discrimination. Then we can be very short on the Hamas attacks on Israel. They cannot be justified, obviously not by reciprocity. And I always wish one of my students becomes a legal advisor of Hamas, because Hamas doesn't even try to make a good argument. I mean, I don't speak about war crimes, I speak about violations of humanitarian law, but somehow they self-incriminate themselves by their discourse. And now let's come to the Israeli reaction to those attacks on Israeli cities. Here, in my view, the big problem is we don't know the facts. And this is a serious problem for humanitarian law as soon as we come to the conduct of hostilities. As all my students know, what counts is not the result, but the ex-ante evaluation by the attacker. So we would need to know, to take one example, this high-rise building in Gaza, which was completely destroyed. We would need to know what Israel reasonably expected to be present in that building, and how important this military objective was compared with the damage. Fortunately, if I understand correctly, it was only damage because there was a warning as IHL prescribes. And there, we don't know the facts. And even if you are in the place, you cannot establish the facts because it's an ex-ante evaluation. So the only people who know today whether there has been a violation or not are the Israeli military and to some extent Hamas, because Hamas knows what was there. So if what Israel recently claimed, in this building, there was a center which tried to produce an anti-missile mechanism, which would make it impossible for Israel to shoot down most of the missiles, then probably the proportionality rule, taking into account also that there has been a warning, and therefore, if I understand correctly, all people were able to evacuate, and therefore simply civilian objects were obviously destroyed, would certainly be respected, while, as we know from past campaigns, if the theory of Israel was that every place where a Hamas commander lives is a command and control center, this is not what how IHL defines a military objective. Also, the Hamas commander, it's himself. I don't think there are many female Hamas military commanders, so I don't have to say herself. It would be still a legitimate target, but obviously there the proportionality evaluation would be totally different. So the problem is simply, as long as we don't have the facts, I don't see how we can say whether there was a violation of humanitarian law or not. It is indeed astonishing how many civilian buildings were destroyed, but we don't know what was in those buildings, and even those people who lived in these buildings do not necessarily know what it was the importance of the building according to the Israeli plan. And this is perhaps a weakness of humanitarian law, that the law on conduct of hostilities is not based like torture. I mean, if you see a detainee who has been tortured, then there's a violation of humanitarian law. If you have, you see a child which has been bombed, it's not necessarily a violation of humanitarian law, although I am against bombing of children. But to avoid this, we have to stop armed conflict. Thank you.
Thank you so much, Marco. What I take from your presentation is I think the important reminder of the absence of the principle of reciprocity in IHL, which in situation of escalations like the one we've seen in May, we can easily forget, and also how important facts are for determining whether violations of IHL have occurred for the purposes of conduct of hostilities, because as you said, it's an ex ante analysis, and unless we were in the room with the military commander who decided, it's very hard to know what they knew and what they've been thinking. I also hope that the question from Stéphane Ojeda on the interplay between the apartheid legal framework and IHL and the law of occupation has been at least partially answered. If Yael and Clive want to come back to it later, please feel free. And I would also like to point out to an expert opinion on the interplay between those legal framework produced by Professor Miles Jackson, which I will put in the chat in the moment. Yael, you have the floor.
Yes, thank you, Emily, and thank you everybody for joining us. One of the reasons that I wanted to speak after Clive and Marco was on the assumption that I'll be nodding my head most of the time, and indeed I have been nodding my head most of the time. And in terms of presenting the issues, I just thought I'd let them do that, and I'll add my tweaks and nuances. And this is basically what I plan to do with the following. So what I'd like to offer is some comments on various points that were raised in both presentations. So first, with regard to what Clive said, so a couple of words about apartheid, and I'm relating here a little bit to legal doctrine and to I'm not sure what I'd call it, pragmatism, so much as possible practical constraints. I dislike the term pragmatism because I think it tends to suggest that we need to compromise on the law in order to achieve something. And I'm not suggesting necessarily a compromise, just there's certain obstacles that we might want to take into account when we calculate our moves. So with regard to apartheid, we need to mention that Israel is not party to the Apartheid Convention, nor to the ICC statute. Now, to the extent that we're thinking in terms of concrete criminal proceedings before the ICC, one might argue that if the ICC has jurisdiction over crimes allegedly committed in the territory of Palestine, then what matters is only the commitment of the state of Palestine. I'm not sure it's that entirely that simple. I think there is a question of establishing the criminal responsibility of individuals hailing from a state that has not subscribed to certain norms, assuming, of course, that these norms are not customary, because if they're customary, then there's no issue at all. Whether apartheid is customary, the prohibition on apartheid is customary or not, I think it's a little complicated. If we don't entirely know what the prohibition means, arguing that it's customary becomes a little more complicated. Also, I'm not arguing that the ICC does not have jurisdictions over individuals, over nationals of a non-party state. But in terms of actually establishing the criminal responsibility, including knowledge and intent, it might be a little more complicated. The other thing is, and that goes a little bit to the issue of the relationship between apartheid and occupation, that the crime of apartheid concerns crimes against individuals that are based on, I think that's what it concerns, crimes against individuals that are based on their belonging to a racial group. And I agree that the term racial in this context can and needs to be, generally speaking, needs to be interpreted more broadly than race in its biological sense, if we know that what that is. But then the underlying assumption is the equality of all persons in the treatment they're entitled to under the law, which oddly enough, when we're speaking about a situation of occupation, that is not the case. And in fact, in the opposite direction of what we would think, in the sense that the law of occupation assumes that individuals belonging to the population of the occupied territories are entitled to different treatment, or at least to a certain minimum treatment of protection, being protected persons. That does not necessarily mean that they're entitled to better treatment than, to put it in concrete terms, it does not mean that Palestinians under the law are entitled to better treatment than Israelis, because the law of occupation does not deal with settlers or with nationals of the occupying power. But the idea of different treatment based to individuals based on their belonging to one group or another is actually underlies law of occupation. And that's not how human rights law in general applies. And apartheid hails from human rights law. So the question of what the relationship between the two is, again, something that I think needs to be examined. What the conclusion would be, we have yet to see it. And I'll say that about most of my comments here. I don't have a bottom line, it should be this way or that. I just think that there's issues that need to be considered carefully before we make any, before we claim any clear-cut answers. So this is with regard to apartheid. With regard to persecution, and in fact, apartheid as well, I think you're right that there's a difficulty in proving intent. Well, two things I would say. One is that the intent is not to carry out the conduct so much as to discriminate or oppress. And obviously, the Israeli answer would be yes, but we have, it's not about oppression; it's about maintaining security, and security is a legitimate concern of the occupying power. So one would think, why not just speak about violations of IHL, where they don't need to be based on an intent to discriminate or intent to oppress. And I think one of the reasons, is that a lot of the, I'm not sure what the word is, I'm looking for something slightly stronger than complaints, but a lot of the complaints against Israel some of them are based on violation of the law of IHL, of the law of armed conflict, but some of them concern practices that are disturbing because even if lawful in themselves one way or the other, they concern different treatment of Israelis and Palestinians. And that is not, as such, is not a violation of IHL, which is why we would want to go to persecution and apartheid that deal with discrimination and different treatment. But this assumes that the practice relating to Israel is a benchmark. And therefore, if this is Israel's practice with regard to Israeli settlers, and it does not provide Palestinians with the same opportunities or did not treat them in the same manner, then this discrimination. But one might ask, why is the way that is the practice relating to Israel taken as a given? And I'll give, I think, one example, and that is with regard to what is today referred to as family unification. Basically, the idea of you live in a territory. To what extent can you bring your family from outside that territory to live with you? And Palestinians living in the West Bank and Gaza, but I'm thinking more in terms of where Israel recognizes the law of occupation in the West Bank, they can't bring in family to live with them, generally speaking. But of course, or they can't just, not even family unification, just moving into the territory. You can't migrate or immigrate to the West Bank. Not even if this was your home ages ago and you left, regardless of whether you lost your status or not, you can't just move into the West Bank. While Israelis can obviously move into the West Bank. Nobody asks any questions. And if you want to bring your family in, then of course you can bring your family in. So one of the arguments is that Israel's, and this is in the third complaint with regard to family unification, that there's different treatment. My argument would be, why is it so obvious that the fact that Israel brings in Israelis, that's taken as a given? Now, the reason I'm giving this as an example is, I'm not sure that Palestinians, that the simple sentence is Palestinians are allowed into the West Bank. This is covered by IHL. I'm happy to plug in a book that I've recently completed with Professor David Kretzmer that deals with the case law of the Supreme Court with regard to the occupied territories. And one of the issues that we deal with, although we intentionally don't go into much detail about, is the question of residence in the West Bank. To what extent can people, do protected persons have a right to return after they've left, to bring in other people as family? It's not obvious. There are security considerations there. I wouldn't say that there aren't, but it's far from obvious. Well, it's obvious that the nationals of the occupied territory, of the occupying power, do not have a right to settle in that land. So again, rather than speak of discrimination in why are Palestinians not treated in the same ways as Israelis, and I think we all know the answer to that. But the question is, why are Israelis allowed what they're allowed? Now, either way, I realize when I say this, arguing with the Israeli government on these things, and these are the practical obstacles that are part of the practical obstacles, I can't even imagine this discussion. I can see how difficult it is. But I think these are some of the questions that need to be dealt with. And I think a lot of the international activity is about either about the comparison or about violations against Palestinians. And there's another element of the entitlements of Israelis in the West Bank. So these, and then finally, one thing I was wondering about, Clive said that there's few attempts at accountability because there's a problem with obtaining the information. And I was just thinking, if we're talking about systematic practice that is entrenched in laws and in administrative procedures and stuff, I would have thought that this is actually the easier thing to prove. But I guess there's a practitioner's perspective here that I'm not seeing, and I'm interested in the answer to that. So these are a couple of comments on that. With regard to what Marcus said about Jerusalem and the law of occupation. So here again, to be practical, any engagement with Israel that would be based on East Jerusalem being regarded as occupied territory is a dead end, because this is obviously not the policy of the Israeli government throughout the generations since 1967, but it's also not Israeli law. So this is something that even the Israeli courts cannot engage with within their own mandate. But a couple of concrete things. One is Marcos said that that there's an obligation to respect Jordanian law because that was the law that was enforced when Israel came in, the Israeli forces came into the territory. And if under, and presumably under that law, the people now under risk of evacuation were the legal owners. And I think if I understood correctly, or because they acquired these laws, these rights, I'm sorry, under Jordanian law. And if I understood correctly what Marcus said, then I think I have to disagree with the facts, because part of the problem is there's two issues here. One is some of these residents received they are refugees from what is now sovereign Israel that have moved into the West Bank to be under Jordanian rule. The Jordanians let them settle in houses in East Jerusalem that had that were owned or had previously been owned by Jews. And they said if under certain conditions, these residents would receive ownership of the houses, but that was actually, the process was never completed. So the problem is that they're not the owners under Jordanian law. I think if they were the owners under Jordanian law, Israel would respect that. Now there's a whole variety of issues there, and the cases in court, part of the problem is that they're all about property law and civil, and the civil law and the rights between individuals, and the state does not, the fact that this is all happening in the context of a political conflict, you can't see it if you look at court proceedings. But the thing is, in most cases, they're not the owners under Jordanian law. That is now being debated. If the court decides that they are the owners, the problem is solved. The problem is, the other problem is what happens if the court decides, no, they're not the owners. And the people who are now trying to evacuate them are the not successors, but successors in law, the trustees of the original Jewish owners. And we have a question of what do you do when you have Jewish ownership and then Jordan takes over the territory as part of a conflict. Now Israel takes over the territory as another stage in the conflict and wishes to give or to allow the original owners to have their property back. I don't think that's a violation of the law of occupation. And if Israel is not allowed to change the situation that was there for 19 years, neither were the Jordanians allowed to do that, because the Jordanians were also in occupation of the territory. So if this was Jewish property taken over by the Jordanians who cannot change private property rights, all Israel is doing is reinstating existing property rights. I mean, this is kind of the argument that is made to the extent that somebody's looking at it, giving it a political context, but still maintaining it as a civil dispute. So I think the question of who was the owner in 1948 is important. And the point is that the specific places where there's evacuation are properties that were owned by Jews. Now, that said, I think what Marco said towards the end is extremely important. And that is that Israeli law allows Jews who have lost their property in 48 to regain it now that Israel isn't getting control of the territory. However, this is different Israeli law that I forget what the word is, but basically takes the property of Palestinians who were not in their homes in 1948 and regards them as absentees, and the law grants their property to the state and does not allow these people to regain their property, even though they may be living not only in Israel, but back next to their homes. They ran away, there was a war, they ran away to the next village, came back a while later, the territory, the land was no longer there. So there's definitely, I mean, if I need to give an example of different treatment based on national affiliation, this is it. This is not only in terms of outcome, this is definitely in terms of intent. Now, one law is from 1950, the other law is from 1968, but when they legislate one, they know what the other one says. There's been 70 years or 50 years, depending how you want to count, to change that if somebody wanted. But here we go back to the issue of apartheid. In order to speak about this as a matter of apartheid or persecution, if you want to go to crime, to international criminal law, then you have to include the territory of Israel in the mandate of the ICC. Now that becomes a little more complicated because the ICC may have jurisdiction over Palestine in the sense of the West Bank, Gaza, and maybe East Jerusalem, but not over the rest of Israel. So there's, you argue one thing, you get a problem with the other. Again, to respond to Marco, this is not the place where Israel would find it easier to argue that East Jerusalem is occupied territory, because that would render so many of its actions unlawful that it's just not worth the cost. But also politically, it's not an option. I think this is where I would stop at this point. Thank you.
Thanks, Yael. That was very dense, but I really appreciate the dialogue with Clive's and Marco's presentation. I'm also sure that some would agree or disagree, but it's a very important and interesting perspective. And I guess this also goes to show that what we're aiming at discussing today is extremely complex. There are current events, but they have legal ramification going back to 1948, 1967. It's highly technical, but also highly politicized in a way. And I think our participants will appreciate you and Marco trying to put yourself in Israeli government's shoes as to what is, as to what is best or most sensible to argue to defend the current position. Not saying that you did this, but pointed out to it. I'll give the floor to Nuria in a second, but because we've had a few questions, if you are all available for 10 extra minutes, so until 2:10, maybe we can try and push and address all the questions we've had in the chat. But let's see. So Nuria, you have the floor.
Thank you, Emily. I'm happy to be on this panel. I actually graduated from the Geneva Academy some years ago. So it's great to be back even in a virtual format. So I'm Nuria Oswald. I'm from the Al Mizan Center for Human Rights. And as Emily said, that's a Palestinian human rights organization that's based in Gaza. We have a mandate that focuses on Gaza as part of broader occupied Palestine. I am no longer based in Gaza. I was for a few years. I'm now based in Geneva, where Al Mizan does a lot of work with the UN in particular. And Al Mizan's work is based on our fieldwork documentation in Gaza. So we monitor both daily incidents relating to international law and then also the full-scale military bombardments like the one that we just witnessed over those 11 days in May. And the majority of my colleagues are, of course, on the ground in Gaza. We have just 2 advocacy staff who are not there. And so every day it means that my colleagues leave their houses at very serious personal risk to go to the sites of bombardment and to conduct interviews, to gather information, to really try to understand what it was that was in the object of attack, who was there, what was in the neighborhood, and to try to make an IHL assessment. Of course, this is extremely difficult, as Professor Sassoli already outlined, but what Al Mizan sees again and again and again, and this is not new to this escalation, is that civilian homes and civilian infrastructure, including, for example, healthcare facilities, without these objects being used for military purposes or having combatants in them, for example, being very clearly civilian in nature, are being directly attacked. And this is a trend that we identified in particular in attacking family homes, civilian homes, in the 2014 bombardment as well. I've been asked to talk about the closure today, so I'll jump in there. But just to say that our field work forms the basis of our legal work. So we pursue legal initiatives at both in domestic jurisdictions in the region, and then also internationally, and we've been cooperating with the ICC since 2015. And our advocacy is also then based on firsthand information that we gather on the ground. Now, one of our main areas of work is, of course, to monitor the effects of the Israeli government's closure of Gaza. And I'll talk a little bit about the legal framework, but also Al Mizan's documentation from the ground. Now, Tamara said at the start that Gaza is an open air prison. And indeed, this is not an exaggeration. I would say it's the world's largest open air prison. It's for 14 years been used to hold around 2 million Palestinians who are effectively locked in this small chunk of territory without access to the rest of the OPT, without access to the outside world. The closure in its current stringency dates back to 2007, so this is after Hamas came to power, of course, but it's in effect an intensification of movement restrictions on Gaza that were already in place from the 1990s. The closure has been repeatedly declared illegal by pretty much the entire corpus of international legal experts and bodies, save, of course, Israel, but this includes the UN Secretary General, special procedures, the ICRC, all reiterating that the closure contravenes IHL. That's because its restrictions target and impose hardship on the civilian population that effectively penalizes them for acts they themselves have not committed. So this is a collective punishment under international law that's prohibited specifically under Article 33 of the 4th Geneva Convention, which forbids collective penalties without exception. Now, the impact of the closure has been...
Nuria, if I can just interrupt you for a second. We can hear you perfectly, but we don't see you.
Okay, I think that's because my signal is not very strong. So now I've actually turned my video off.
Okay, perfect. Then let's keep it like that. Sorry for interrupting.
Oh, that's okay. Thanks for pointing it out. So I was just about to say that the impact of the closure has been extreme economic decline, with unemployment now at 48%, and what is really a wholly preventable human-made humanitarian disaster. So food insecurity is over 68%, 80% of households are receiving humanitarian aid, and then water and electricity are critically scarce. The current closure is not made up of a single ban, a single rule, but rather it's a comprehensive package of restrictions that actually individually themselves violate a spectrum of human rights. And of course, Israel is also a duty bearer under international human rights law in Gaza. Now, part of this package of restrictions is means that Gaza is sealed off by land, air, and sea. It also entails the enforcement of an access restricted area. So that's a kind of buffer zone implemented by Israel on Palestinian territory in Gaza. And so here the Israeli military uses live fire to enforce its restrictions. In particular, there are fishermen and farmers who are in this restricted access area, which I should note is largely undefined. And 35% of Gaza's agricultural land is in this kind of buffer zone. And the restrictions entail the destruction of farmland, restrictions on the fishing zone, et cetera. And then at its core, at the closure's core, are the movement restrictions, which I think people are probably most familiar with, which are imposed on people and goods. There are very tightly controlled exceptions, mainly falling under Israel's humanitarian exception, they call it, which allows for some patients to travel through Israel's very complex and slow permit regime. The closure is touted by Israeli authorities as a security measure, but the restrictions aren't militarily necessary and go far beyond what is permissible in international law. And indeed, Israeli officials have been clear over the years that it is a strategic policy, one to separate the West Bank from Gaza. And while Gaza and the West Bank have been recognized as one entity in international resolutions and previous agreements, including with Israel, Israel's annexation and demographic goals are served by isolating Gaza and preventing its connection to the rest of occupied Palestine. And even within the permit process itself, we see the security argument kind of break down. So one of El-Mizan's areas of work is to represent patients whose care is not available in Gaza, get permits in order to travel for care to the West Bank or Israel. And many of those patients are have received denials for permits on the basis of their security background. So they're being deemed a security threat and they are therefore denied the medical permit. Now, all El-Mizan does in those cases is really just file some paperwork that the patients have filed themselves. So we file it directly with the Israeli authorities. And in more than half of those cases, the security denial is overturned, which really points to the fact that there wasn't a security element to the denial of the permit to begin with when it's overturned by an organization filing some administrative papers. There's something very similar that happens with my colleagues, for example, or other people that I'm aware of as well, who have been denied permits on the security basis, but then are granted permits on the medical basis. And so somehow this security threat in their background is overturned. But then again, this is including for my boss who had cancer, but then again, when he was in remission, was denied permits again for work on the basis of a security threat within his background. So just to say that Israel's effective control over Gaza also includes administrative control, so over telecommunications, over the population registry. And I mention effective control because in 2005, Israel vacated its formal presence in Gaza, so it removed its settlers, it redeployed its troops to the perimeter fence, but still continues to control Gaza through this web of restrictions that I've described, and then also has boots on the ground through regular incursions as well, and grounded invasions during some of the full-scale military assaults. The UN, the ICRC, and other legal bodies have reaffirmed in the years after the 2005 disengagement that Israel retains its status as occupying power because of this effective control. And Israel's obligations under occupation law are therefore commensurate with the degree to which it exercises control. So take, for example, the occupying power's obligation to ensure access to healthcare. In Israel's occupation of Gaza, this translates into an obligation not to impede or obstruct medical services. So this is a negative obligation. And in practice, what Al-Mizan sees is that Israel's closure directly results in shortages of medicine, supplies, equipment, expertise, all these things that are necessary for healthcare in Gaza. Now, during and after the 11-day escalation in May, the stringency of the closure was increased. So the commercial crossing was completely closed during the escalation, and since has only been partially reopened. So this impacted the entry of fuel in particular, and had huge repercussions for access to water and sanitation, with there already being an underlying crisis in that regard. At the same time, the COVID-19 pandemic persists in Gaza, and the vaccination rate is extremely low. It's something like 2% of people being fully vaccinated. The criteria for patients to travel was further restricted. Patients were banned during the bombardment, but further restricted until the 3rd of June to allow only those whose lives were in immediate danger and requiring intensive care. Cancer patients were then left out of the permit system, patients with chronic illnesses as well, people who were injured in airstrikes. And in that period, there were 2 patients who died after they were unable to obtain permits under the criteria that was applicable for that period of time. The restrictions are also still in place, preventing building and rebuilding in Gaza post-bombardment. So there were 140 buildings damaged or destroyed in those 11 days. Many of them held multiple housing units, and there are still around 8,000 people who are displaced. And then I would like to highlight that that Israel's closure it forms part of its larger discriminatory system and systemic repression of Palestinians as a whole, which amounts to the crime of apartheid, as has already been discussed, and that it constitutes punitive and persecutory measures as well. And yet I ended with information on how the closure restrictions are increasing to show that now 14 years on, it's being ramped up. Despite its unlawfulness, despite its repercussions on the humanitarian situation in Gaza, it's being made more stringent rather than being fully immediately lifted. And we don't have time to get into this now, but the reason for this is clearly impunity. Impunity that's granted to Israel by the international community, and notably for the root causes of the conflict, which include, of course, closure, but within the bigger, the larger discriminatory system that Israel maintains, and systemic repression of Palestinians as a whole. Thanks, Emily. Back to you.
No, thanks a lot, Maria. That was very extensive, very clear, and very well constructed. And I think one of the main challenges to apprehending the legal but also factual situation in Gaza, is Jerusalem, and the rest of the West Bank is that you can consider the Palestinian territory as a unit, as a single unit composed of different parts. And and consider the discriminations and violation going into each part as part of a whole, and then see through the apartheid lens. But on the other hand, the Israeli government consider Gaza as not occupied. What I'm trying to say is the Israeli government applies a different legal framework and has different kind of argument for different parts of the occupied Palestinian territory, which renders conversations on facts, but also on the law, quite challenging. And I think it's one of the aspects that today's panel is showing, is that depending on the lens you choose and the territory you're talking about, you can have an entirely different conversation. And one of the things that I see changing is that Tamara mentioned that people are starting to apprehend the Palestinian struggle or the question in a more comprehensive way than has been done before. And this, I'm excited to see how it's also going to affect the legal conversation. We have received a lot of questions. Hopefully we'll get to address all of them or some of them. I'll start with 2 questions on the law of conduct of facilities that we've received from Stefan and Tarek. Marco and Yael, feel free to answer them. I'll direct them to you, but if Clive and Nuria also want to add to them, please feel free. The first one is, can a single apartment, let's say a lawful military objective at the time, if it's located in a multi-story building, can its mere presence turn the entire building into a lawful military objective from an IHL perspective? And then with regards to warnings, could one make the argument that rockets initially fired by Hamas are warnings rather than, you know, attacks per se, because of the asymmetrical nature of the conflict? It's a bit of a stretch, but I think it's an interesting question. Marco or Yael, do you want to go first? Okay, Marco, go ahead.
You want me?
Whoever is more comfortable.
No, I mean, the single apartment issue is a debated issue. Be conscious that it's only of minor importance, as if it is only possible to attack the single apartment by destroying the whole house, it's an issue of proportionality, because if the whole house is a military objective, then the military objective itself does not count, and therefore the destruction of the entire house would not count. But obviously of the civilians in the house, their killing or injury would nevertheless count. And so the answer is, this is controversial. If you take the law at the letter, you would say, if this is a military objective, it doesn't count. But I think there are good arguments to also say the opposite, which is that the other apartments are still civilian property, and so you have to take into account the effects on that civilian property. On the second issue, the rockets initially fired, here again, this is my dream, that one of my students becomes a legal advisor of Hamas. This was simply not the argument made by Hamas. They didn't say, and it was not meant as a warning. If they had done it, then we would come into the discussion which has been made against Israel in the 2014 conflict, whether the knock on the roof is not an attack and therefore an unlawful attack if you attack something which is not a military objective for the purpose of warning. And I think there are other ways of warning than to send rockets. Thank you.
Yeah, let me just add on the last issue that if it is a stretch, because if we regard it as a warning, it's a warning of what? That there's going to be another attack on a civilian population. The point of warning is we're going to attack a military objective, not we are about to violate the laws of war. So, but again, like I tell my students when they make an argument that I don't think works, I said, that's what makes a good lawyer. You try these things. Yeah.
Thank you. Does Clive or Nuria want to add something? Okay. Then we'll turn to the next question. And I'll rephrase it a bit. And Clive, maybe you want to take it. What is basically the legal status of the Al-Aqsa compound compared to the rest of East Jerusalem? Is there a difference? And if so, how does human rights law apply on it? Or whoever feels I mean, I thought Clive would speak to it, but I see Yael.
No, Clive, go ahead.
Okay.
It doesn't. I mean, whatever the status of East Jerusalem is, and that's disputed, that would also, as far as I know, would also apply to the Al-Aqsa Mosque. Now, there is a question of control or management of the holy places, but that's not a matter of the status of the land, so to speak. With regard to human rights law, human rights apply everywhere. So I don't think it would make a difference to that.
Yeah, Clive, do you want to add?
Yeah, sorry, I was just trying to find the exact question, but I mean, on that general point that Yael just said, that's it. And I think some of the other questions, sorry, too, have been talking about this as well. It's that, yeah, IHL applies during armed conflict and during military occupations and those areas. Human rights law applies everywhere at all times. It can be limited in or derogated from in situations of states of emergency threatening the lives of a nation. And international criminal law applies. I mean, if it's the ICC, by jurisdiction, by state, or by nationality, but customary international law, clearly by definition, applies much more broadly. So particularly the human rights law is that it does apply everywhere. It's not excluded by the application of IHL, whether armed conflict or putting it as an alternative occupation. It may be complementary, and that's the key issue. How do we complement the two, particularly in a long-term occupation? Where, sorry, there's a lot that could be said. I mean, to say very briefly is that in a long-term occupation, you can say the systems of governance, the day-to-day issues come to the fore. And that's where, I'll put it, regular human rights law may be more important. And also any justification for limiting human rights, particularly in severe forms, becomes less and less the longer you go on, the more you can adapt your systems to ensure that basic human rights are protected. And one final point on that as well is that not just apartheid or persecution as crimes, but the prohibition of racial discrimination is a fundamental principle of international law, which should never, or certainly almost never, can be justified. That means, though, that some forms of differential treatment may be justifiable, but again, only in the most extreme situations and only in a very proportionate way. And in the long term, it's very difficult to justify anything that appears to be racial discrimination.
Thanks, Clive. We'll go back to differential treatment in a minute because we've had several questions. But first, one that we've had is, can Palestinians settle back in Israel under the law of return? Or is there a right to return for Palestinian refugees under international law? Nuria, do you want to try answering it, or otherwise whoever feels more comfortable? Nuria, can you hear? Maybe you're on mute.
Oh, sorry, I was on mute. I actually didn't catch the question, sorry.
Can Palestinians settle back in Israel under the law of return, which is national Israeli legislation, I assume, or is there a right of return of Palestinian refugees in international law? But I'm happy to give the question to somebody else.
So I would just point quickly to the right under international human rights law to return, which allows anyone to return to the country of their nationality. So I would very simply point to international human rights law, but maybe Clive or one of our other experts has a more comprehensive answer.
Thanks. Clive?
Sure. I mean, just on international law, as you just pointed out, human rights law says anyone has the right to return to their country of nationality. Then, of course, there'll be discussion about nationality when that has been deprived because of a situation. There's a very accepted right to return associated with refugee law, particularly after armed conflicts and forcible displacement. There is no one should benefit from international crimes, including forced displacement of the past. Then it comes to, you might say, historical, and is there exceptions that refugees by descent have a right to return? There has been many times a growing acceptance of that. And you see it in other areas as well, sort of indigenous peoples, many generations later, where it's possible have a right to return. It becomes very much then you apply it in a different way where it's possible to do so and the state has to adapt to that. In the situations where it really is not possible or the people no longer wish to return, there's still then a right to compensation. So it still has to be worked out on a case-by-case basis, but there's a very clear right to return under international law.
Thanks, Clive. And if I may add, I think the right of return of the Palestinian people has also been recognized by, organs of the United Nations. Does Yael or Marco want to add anything on this topic?
Yeah, okay, so there's a bit of disagreement here,
Okay.
finally. So the right of return under international law, it's the right to return to their own country. I mean, in fact, it doesn't say nationality, but that's been the traditional interpretation. And then the question is, what happens when a person is not a national? And the question is, why are they not nationals of the country? The assumption that all Palestinian refugees are refugees because of the commission of crimes, I think, is a little excessive. The other thing is that, so I'm not sure international human rights law provides complete answers. Refugee law contains the right to return, generally speaking, but neither Article 12.4 of the ICCPR, which is the right to return under international human rights law, nor refugee law provides an absolute right under whatever circumstances. So the question might be, there may be a right to return, but the question is when, and that makes it a little more complicated, with Israel's argument to some extent being that there's a security risk. Whether that is the complete answer, whether that is the answer, is highly debatable. One last thing, at the end of there was one other point that I wanted to make with regard to the right of descendants. Two things. One is with regard to the right of descendants. It is true that there have been cases where the right of descendants to return rather than the original refugees has been recognized, but I don't think we could say that this is the accepted international understanding of the right. And finally, you're right that the right of return of the Palestinians specifically has been recognized internationally, but it's been recognized by political bodies and, surprisingly enough, resting on Resolution 194, which does not actually give an absolute right of return. So I would suggest to base that right not on existing General Assembly resolutions, not only because they're not binding in itself, but because what they rely on is not binding law or not a legal obligation.
Thanks, Yael. And if I may add, the right of return or the fate of Palestinian refugees in neighboring countries is one of the outstanding issues that still needs to be negotiated between Palestine and Israel if they ever come to a peace agreement. Can I still have 5-10 minutes of your time so we can continue with the questions? Wonderful. Thanks a lot for your flexibility. So we've had two questions that I think can be grouped in the cluster of differential treatments. The first one is, do the rights of protected persons under GC4 prevail over the human rights of an Israeli settler in the OPT, regardless of that settler's legality, the legality of the settler's presence? And the other question is specifically for Marco, but that I'd be curious to hear the others on it, is Article 20. It's very precise, so I will read it carefully. You appear, Marco, to take the view that Article 27 of GC4, which establishes that all protected persons shall be treated with the same consideration by the party to the conflict in whose power they are, without adverse distinction based in particular on race, religion, or political opinion, only prohibits adverse distinction between different groups of protected persons. So not Palestinian versus settlers, but groups of Palestinians. Do you think, though, that the provision should be read as also prohibiting adverse distinction for the benefits of nationals of the occupying power who are present in the territory as a consequence of violation of Article 49 of GC4? So yeah.
Yeah, so thank you very much. My answer on Article 27 is clear, yes. It is limited to protected persons, and it is lawful, if not required, that an occupying power treats non-protected persons in a different way than protected persons. Now, the issue with the settlers is if these settlers have been unlawfully moved, as most of them have been moved by an Israeli policy into the occupied territory, then this becomes one of these hypothetical questions which I don't even like to put in an exam, because it is okay, they shouldn't be there, but then if they are nevertheless there, should they be at least treated like the local population who are protected persons, or isn't this at least a non-discrimination that they cannot be treated in a better way? Does IHL prohibit to treat them in a better way? Here, probably human rights law is the lex specialis about the treatment of non-protected persons, because there could be non-protected persons. Sorry that I have to remind you that there is no prohibition for Israelis to live in the occupied territories. The prohibition is Israel may not have a policy to move them to the occupied territory, and indeed, international humanitarian law, or especially the law of occupation, deals mainly, nearly exclusively, with the protected persons. So how protected persons must be treated compared with non-protected persons, this is not an issue IHL deals with, and would indeed be a human rights issue, and therefore there may be no discrimination in the sense of if non-protected persons are better treated than protected persons, this would be a human rights violation, while the opposite, if it is justified by obligations under humanitarian law, I don't see a problem.
Thanks. Does anybody else wants to jump in?
Yeah. Yes, I think at the end, Marcus said at the end that if protected persons are better protected or have better treatment than non-protected persons in a way that is not justified by international human rights law, then you said there's a problem. But I think if they're better protected because of the law of occupation, protection under the law of occupation, then that would prevail. And that also answers, I think, the question, Stefan's question, whether the rights of protected persons prevail over the rights under international human rights law of the settlers, of the Israelis. And I think the answer is that the rights of Israelis are circumscribed by the law of occupation. So this was said even by the Supreme Court in the context of the disengagement from Gaza, where it said that the property rights of Israelis in the Gaza Strip are circumscribed by what international law allows the military commander to even grant them. So they have no more rights than international law allows. Now, this was not in the sense of a protected person against an Israeli, but if it came to that, the rights of protected persons are absolute minimums. If the need to comply with that protection is a legitimate restriction on a human right of another person. So I think by definition, the rights of protected persons prevail over the human rights of non-protected persons. Yes.
Thanks a lot, Clive.
And yeah, just briefly on what's a very important question is to say, as we said before, human rights apply everywhere to everyone, but human rights themselves, most of them are limited and can be limited. So everyone in the territory, including settlers, has human rights, and the states have a duty to respect them. But the most basic ones, like the right to life and freedom from torture. But when it comes to something like property rights, would be a good example of where the rights for protected persons to their property and land, and going back to the beginning of the occupation, would, you imagine, in most, in fact not all cases, prevail over what would be an unlawful settlement. And people whose land was seized unlawfully under occupation law.
Thanks. Nuria, do you want to add anything?
No, thanks. Please carry on.
Then actually the next question, I would like to give it a try. So should the 14 years old closure, the recent COVID crisis, and as you mentioned, the ramping up of restrictions in Gaza, somehow influence the legal analysis of the latest round of armed hostilities?
Shall I start?
Yes, please.
Okay. So I think that it absolutely should, and particularly for this reason. So Israel's campaign on Gaza included the bombing of civilian infrastructure vital to the survival of the civilian population, like wash infrastructure, right? So infrastructure in the wash sector, water infrastructure, sanitation infrastructure, the sewage processing plant, really further crippling Gaza's ability to maintain clean water. The natural aquifer there is already 96% polluted, but to maintain what is left of clean water and sanitation. IHL requires that due regard is paid to the consequences of attacks. And so in this way, we're looking at this tiny coastal enclave, which, as I described, is already under a humanitarian catastrophe, with COVID still spreading without vaccines. And then on top of that, with military hostilities that clearly did not pay due regard, at least to a certain extent, of the consequences of military action, thereby dramatically exacerbating the humanitarian situation in Gaza, in particular in relation to health.
Thanks, Nuria.
May I just,
yeah, of course.
May I just clarification? I know that Nuria knows that, but perhaps some listeners don't know it. Obviously, to attack civilian objects is always unlawful. Therefore, it's not even a discussion. It's in Geneva like in Gaza, where what Nuria said plays a role is in the proportionality evaluation, which is only relevant if this was a military objective. Then you have to take into account what are the side effects of destruction of civilian objects, incidental destruction of civilian objects on the civilian population. And there I obviously more than agree that in a situation like Gaza, but also in Yemen and so on, there is much more effect of attacking a military objective if incidentally you destroy the wash infrastructure.
Thanks, Marco. Yeah, Clive? No, okay. Then I'll ask one last question to all of you. Apologies to those who have been very active on the chat and whose question won't be answered today. So do you think that, after an occupation that has lasted for this long, and also the amount of violation that we've seen affecting both sides, but maybe perhaps more so the Palestinian one, do you think that IHL is any good for Palestinians, or is gonna be helpful towards finding a solution to the conflict? I'm asking this to the four of you, and for our participants, I'd like to point out that Diakonia IHL Center has recently had a conversation around this topic. I don't know if it was recorded, but if it was, I'd be curious to have the answer. But Clive, Nuria, Yael, Marco, is IHL useful after all this time, and is it going to be conducive of finding a solution?
Okay. So if I go first on that, is to say, maybe this comes to the nature of our work, IHL together with human rights law, together with other forms of law and international criminal law, should be used together. And I won't go into broader issues about the limits of international law, but it's about are we clear about what's a violation? Are these laws being used to protect the population? And when there are violations, is there accountability? Is there accountability of the state? And if it's international crimes, are there accountability of individuals? So I think we can say that they've had, in some ways, limited effectiveness over the years, and not just in this occupation, in other occupations around the world. But on the other hand, the fact that people are still talking about it, still feel obliged even to say they are compliant, even if they're not. So it's a degree of compliance. And when it comes to what we started with the international crimes, it's really a starting point is saying these are international crimes. Those who are both victims of them and those who are committing them need to be aware of that. And then there does need to feel that there would be accountability. We're not at that stage, but when we do get towards that stage, then we can say all the law coming together has a form of protection.
Thanks. Who wants to go next?
Is IHL useful? I think the question is, what is the alternative? I think it's, again, like Clive said, together with other bodies of law, but no, I would not replace it. Can it solve the conflict? No, the law can never solve a political conflict. No body of law, IHL or otherwise, can resolve the conflict. That the law can only give the answers as far as the political will is there, and what's required is the political will.
Thanks. Nuria, maybe?
Sure. Yeah, I'm not going to add anything too interesting. I really agree with what my colleagues have already said, and it is the way that El Mizan operates to apply or to rely on IHL, but to rely on other bodies of international law as well. But I mean, we recognize the factual circumstances being that IHL does exist. IHL is a legal framework that is relied upon. We are feeling more hopeful than usual in this moment because the ICC is finally investigating, and we are fully aware that those investigations will also rely on IHL. So it forms part of our work, certainly, but it's one of the legal frameworks that we rely on.
Thanks. And last but not least.
Well, I think, yes, it obviously matters. Imagine we would have exactly the same humanitarian situation, but in a situation where there's no occupation. I mean, one would much less care. And many Israeli policies would simply not be violations, including, sorry that I'm so obsessed about the settlement problem, the settlement problem is not a violation of human rights law, although it obviously provokes violations of human rights law. We agree. So I think it's the best thing the Palestinians can get, although they are obviously frustrated, but it makes a difference between that situations and 100 other situations in the world where people are suffering. Now, the law of occupation was not made for such a long-term occupation, but I would caution everyone to say, okay, therefore we have to interpret it differently because it's a long-term occupation, because you can also, and a lot of Israeli, including the Supreme Court, makes the argument when it's a long-term occupation, we have to interpret that more flexibly. I think we have to stick to what we have, and if anyone has the illusion that you could in the next 50 years revise the law of occupation and make a special convention for long-term occupations, please go ahead.
Thank you so much, Marco, for this last little bit cynical notes. I want to thank the four of you and Tamara as well for your time today, for your insightful comments, for the very rich conversation, for sticking with us a little bit longer than expected. Thank you to everybody who participated, asked questions, and enjoy the rest of the day, and we hope to see you soon for another talk at the Geneva Academy. Good afternoon, everyone.